Hi, this is Blaine Cluten for Cluten Law. So, one of the questions that I get asked is, what is negligence? And I think that the most typical way that I describe negligence is by actually defining what negligence is and then defining the elements of negligence. But generally speaking, negligence is a cause of action that you can bring in Oregon for somebody doing something that was a foreseeable risk of harm. And it's kind of right in the name itself that their act was negligent. But let's go over what first the definition of negligence is. And this comes from a case, Woolston and Wells originally. And as you can tell, I'm reading to make sure that I get it precisely correct. A person is negligent if the person fails to exercise reasonable care, a standard that is measured by what a reasonable person of ordinary prudence would or would not do in the same or similar circumstances. So that's the definition of negligence, and it's kind of a mouthful. A lot of times in the law, we talk about what a reasonable person would do and the reasonable person standard. And this was originally outlined in a case by a learned hand, an old justice, or an original justice, or a long ago justice, that talk about the standards of what a reasonable person would do. Reasonable person standard is can be somewhat flimsy, flexible, but generally that's what the jury is there to decide is the definition of what a reasonable person would do in the circumstance. Now that we understand the broad definition, although it's kind of flexible, let's talk about the elements of negligence. So the first one is that the defendant's conduct caused a foreseeable risk of harm. The second is that the risk to an interest of a kind that the law protects against negligent invasion. That the defendant's conduct was unreasonable in light of the risk. That the conduct was the cause of the plaintiff's harm, and that the plaintiff was within the class of persons and the plaintiff's injury was within the general type of potential accidents and injuries that made the defendant's conduct negligent. And this comes from a line of cases that discusses these 5 different elements. And most recently, it came from Sun v. Ashland Community Healthcare Services in 2010. But before that, it came from Solberg and Johnson in 1988. But suffice it to say that once we know that there is some sort of negligence, we then have to break down within these elements and fit into our case all of the facts and show that they're negligent in each one of these respects in order to prove our case for negligence. So that's what a negligence case is generally. When a person would come into my office and we're discussing their case in particular, and we're exploring the different types of tort actions that they have available as a remedy at law, one of the things that we'll do is we'll look through these elements, or at least I will, and align the facts of their particular case and make sure it fits within these elements of negligence to make sure that they have a cause of action for negligence and it's not some other kind of tort, or they have no remedy available because it wasn't in fact negligent. If you have further questions about what is negligence or whether your particular circumstance, whether your fact pattern, whether the injury you suffered was in fact negligent, please do talk to an attorney to make sure that you understand your rights. This is Blaine Cluten for Cluten Law. Thank you.